Good morning. Happy Tuesday. I was asked in my comment section to show how presidential executive orders are, in fact, uh, superior to, insofar as they deal with federal issues, how they preempt state laws. And that's a pretty easy task to do. There's only two real steps that you have to take, and both of them are pretty simple. Number one is you have to figure out whether or not a presidential executive order is in fact a law, if it has the force of law, if it's a federal law. The second thing that you have to do is you have to understand that federal law is the supreme law of the land. It preempts everything. Now, of course, federal law is broken down into subsections, with the Constitution being the supreme law of the supreme law of the land. But we'll get there. So in order to prove my point, I am going to use one case. It's a Supreme Court case, U.S. v. Armstrong, 18 U.S. 154. It was published right after the Civil War. And it refers to a proclamation, a presidential proclamation. Now, back then, they used different words. They didn't use executive order. They called it a presidential proclamation. But in the case, the judge states, the Supreme Court states, that the proclamation referred to is a public act, meaning it's a law, of which all courts of the U.S. are bound to take notice, and to which all courts are bound to give effect. Now, you can argue that that is referring to just U.S. like federal courts that they're talking about there, but you can argue with, what you cannot argue with is that the court is saying it is a law. It's a public act. It's a law. In fact, it is recorded in 15 statutes at large, 711. Presidential proclamations are treated as law. They are law. Now, they are law insofar as they derive their power either from some constitutionally recognized power of the president from Article 2, or where Congress has explicitly or implicitly granted power to the president to act. Just for an example, a power that's granted by the Constitution would be, for example, to control immigration or to make treaties with other governments. They're not called executive orders. They're called executive agreements if it's based on his power to enter into treaties with other countries. And you can see executive agreements, like, for example, if the president said that all waters within 10 miles of Mexico, for whatever reason, if he said all waters within 10 miles of Mexico are restricted to allow only for boats of Mexican registry to fish from those waters, he could do that, presumptively, unless there is some act of Congress that is in the way. And Texas saying, no, wait a minute, we want Texas registered boats to be able to fish those waters. That's just, sorry. If the president's executive order or executive agreement is otherwise constitutional, then and not preempted by a statute of Congress, then it would be in effect and give in effect, and it would preempt state law to the contrary. So like I said, even assuming that particular case, Armstrong v. U.S., was referring to just federal courts, you got to continue on and look at Article 6, Paragraph 2 of Article 6 of the United States Constitution. You know, that supreme law of the land, that pesky little thing. And it says, and I'm going to paraphrase very loosely here, it says, the Constitution and the laws made in pursuance thereof shall be the supreme law of the land. The Constitution and the laws made in pursuance thereof. Now, I'm missing some words and things like that because my memory isn't perfect, but all the treaties that are derived from the Constitution, that are derived from powers assigned to, like, the president and Congress and stuff, all laws that are derived from the Constitution in some roundabout way, i.e., either if the president was directly given the power or if he was given it explicitly or implicitly by an act of Congress, shall be the supreme law of the land. And the judges in every state, shall be bound thereby. So I think that's pretty clear that the president's executive orders are in fact law, and they do in fact preempt state law. They don't preempt acts of Congress, because if Congress has made the law and the president signed it into law, or a president has signed it into law, some other president can't just by executive order undo that. So the acts of Congress, the statutes enacted by Congress and signed into law by the president, do supersede that. Same with treaties that were entered into by the president and were, I forget what they call it, ratified, I believe, by Congress, passed by Congress, essentially written into U.S. law by Congress. Those would also supersede executive orders and executive agreements. But that's it. I mean, it's pretty cut and dry. So if someone is perhaps confused about what a presidential proclamation is, I could see where they might not understand that. But otherwise, it's pretty clear. It's not really one of those subject to debate kind of things or up in the air kind of things. You see a lot of presidential executive orders directing executive agencies with regulatory powers to regulate in specific ways. And those have the force and effect of law. And of course, regulatory agencies, those executive agencies, have regulatory power that is explicitly or implicitly granted to them by Congress, but are deriving their executive powers from the president and from the Article 2 of the Constitution. Their regulations preempt state law. I mean, it all makes sense. The problem a lot of people run into, I think, is that they don't have enough understanding of all the surrounding issues. I think there's a reason why in college they teach people a little bit of everything. It's to give you that kind of base understanding of most things, so you can have a better basis by which to extrapolate how you could derive at other things, to give you more tools in your tool belt. Same thing with law school. Law school, you're required to take a wide variety of courses. You don't just go to law school to be a family law attorney. I mean, family law was one class in my law school. I don't know if you'd call it a career. My time at law school, I took one class on family law. So I mean, it's something where if you don't have that kind of basis, that broad basis understanding, if you're not really familiar with the Constitution, if you're not really familiar with how to read Supreme Court decisions, I can see how it can be tricky. Anyway, thanks for watching. Have a great day.